My name is Joe Lewis, and welcome to another episode of Justice Now. Tonight's show is going to be a basic educational show, a special show that in my heart, I feel is very important that I do, due to the fact that I have had clients, and all of you out there know that I do court advocacy in the family court, and I have had clients who had no idea of how the family court works. And being in court with those clients, I've also seen other individuals in court seeking judicial remedy who also suffered from the same basic problem. They didn't know which court to seek which type of judicial remedy from. They had no idea of who the individuals, as far as legal players in the courts were. They had no idea of the difference between a magistrate, a referee, or a judge. They had no idea of how to go about seeking a judicial remedy, and if that judicial remedy was not satisfactory to them, what would be their options after that? Could they appeal to a higher judge and things of that nature? So today I'm going to do an educational show on the family court system. Basic general information for individuals who may be in the process of seeking some type of judicial remedy from family court. And for those who have already been to family court, you may hear some of the things that I go over may sound familiar to you. You may already know them. And still, I would ask you to pay very close attention, because there may be some things that you are not aware of. But all in all, I hope that the information today that I will be giving you will be very helpful to helping you understand how to basically maneuver through the family court system and how to better deal with the legal officials who will be adjudicating over your case and assisting you in litigating that case in front of a judge, magistrate, or referee that you may encounter in that court system. Now, this will be the first of probably 3 shows that I will be doing on the family court system, as well as Child Protective Services. I think that it is very important that individuals dealing with these courts have a better understanding how these courts work and how these courts function, and have a better understanding of what the job is of Child Protective Services. What are they mandated to do? What are they not mandated to do? So that with this education, the expectations are within due bounds of what the courts and CPS can do under New York state law. First, I would like to start off with some basic general information, historical information on the family court system and when the Family Law Act basically went into effect. Now, the Family Court Act of 1962 established the Family Court of New York State and gave the court jurisdiction over most cases involving families and children. Now, the Family Court hears cases involving such issues as the abuse and neglect of children, violence and abuse amongst family members, paternity, custody and visitation, support, guardianship, persons in need of supervision, which is better known as PENS, foster care and review and placement, and juvenile delinquency, all described in greater detail in Section 4 of this guide. Now, Section 4 we will be going through Section 4 in detail in probably one of the future shows. Now, in addition, it shares jurisdiction in adoption cases and surrogate court. However, the family court does not handle divorce, separation, or annulment proceedings, which are reserved for the Supreme Court. Now, general information about the family court. Now, there is a family court in each county of New York State, including the 5 boroughs of New York City. These courts are open statewide Monday through Friday from 9 a.m. to 5 p.m. In addition, some courts have a night or evening session several times a week. The courtrooms and hearing rooms are closed at midday for lunch and recess, but areas of each building remain open to the public during that time. A list of locations of every family court in New York State can be found on your basic websites. All you have to do is just basically Google or Yahoo a family court listing of family courts in New York State. It'll bring you up all the listings of family courts throughout the New York State area. Now, this section is about public access to recordings in the family court. Now, the family court is open to the public. This means that the public, including the news media, have access to courtrooms, public waiting areas, and other common areas of the courthouse. However, judges in family court may exclude the public from the proceedings in which privacy is in the best interest of the parties involved. All proceedings in the family court are recorded, most often by tape recordings. Either party, with requesting party bearing the cost, can request a transcript of the recordings or a duplicate copy. Now, usually in custody and visitation court, there's usually transcripts like you would find in a criminal court. And I believe in our, at least in Rochester, I don't know about any other courts in New York State, but I know at least in Rochester, in our child support court, the proceedings are usually tape recorded. So what you would have to do is go to the third floor clerk's office, and you have to bring your own blank CD and request a copy of the court proceedings. It usually takes them a week to be able to do that for you, free of charge. It costs you absolutely nothing to get a copy of your recorded proceedings in the child support court. So you will be able to obtain those. And in your visitation and custody court, you should be able to get transcripts of what went on in that court proceeding as well. Now, next, what I would like to do is go through some basic terminology in the family court and how it differs from criminal or civil court. Now, as you know, in criminal court and civil court, and for those who don't, the term for an individual who is seeking some sort of judicial remedy is better known as the plaintiff. In the criminal court and civil court, that individual who is pressing the charges, looking for judicial remedy, is known as the plaintiff. In the family court, we call this individual the petitioner of the court. Also, in the criminal court, the individual who is the focus of the allegations being made, that individual who is being charged or maybe even being sued, is better known as the defendant. In the family court, that person is known as the respondent. In the criminal court and civil court, they have what is known as trials. These are the proceedings in which they try to cipher through all the facts and try to determine which party deserves the judicial relief requested by their assigned counsel. In the family court, these proceedings are known as fact-finding hearings. I want to say that again. These proceedings are known as fact-finding hearings. Once that trial is over with, you're probably familiar with this term in the criminal court, used in the civil court as well, and that is the sentencing. That is the time in which the judge lets the defendant know what his legal opinion is on the outcome based on the facts and the law and how it applies to that case. In the family court, this is known as a dispositional order. Let me repeat that. This is known as a dispositional order by the judge. Okay? Now we'll go through some other things. In this section, we're going to talk more about who's who in the family court system, so that you get a better understanding of who are the officers and how they serve in the family court system. Okay? Some of these individuals we're going to be going through are going to be judges, support magistrates, court referees, and judicial hearing officers. Now, judges in the family court, the judge is in charge of the courtroom. Judges listen to witnesses, examine evidence, and decide any legal questions that arise during the proceedings. After this information is presented, they determine the outcome of the case and issue any necessary orders in that proceeding. That is the job of the judge in a family court system. Now we're going to talk about a magistrate. Okay? Now, magistrates, formerly known as hearing examiners, in child and spousal support, paternity cases, and a support magistrate rather than a judge conducts the hearing. Support magistrates listen to witnesses, examine evidence, and determine the outcome of cases based on the information presented, issues both orders of support, and however, the decisions made by support magistrates can be appealed to a family court judge. Now, the court magistrate is the individual that you will encounter going into any court involving child support, involving paternity, and any type of child support court orders that you may have. That individual is a court magistrate. Okay? Court magistrates are also lawyers. They are not judges. They are lawyers. And I will explain to you shortly how these individuals are selected and placed into the positions in the court to be able to help the court determine how child support will be paid in certain cases. Okay? Now we have the court referee. A court referee is an attorney who is assigned to hear, decide, and issue orders in certain types of cases. In New York City, court referees can participate in permanency hearings, determination hearings, and cases involving such issues as custody, visitation, and extension of foster care placement. Generally, court referees hear cases and report their recommendations to a family court judge unless the parties agree to have the referee hear and determine the outcome of the cases. Now I'm going to read that last part to you again, because I think this is very important involving the referee in the family court. Generally, court referees hear cases and report their recommendations to a family court judge unless the parties agree to have the referee hear and determine the outcome of their case. Now, when you file for visitation, for your any type of visitation petition to have visits with your child, you will be sent a copy of your petition. On the front of that petition, it will have your court date. That very first court date, you will be sitting in front of a referee. The referee will hand you a form. That form is to be filled out by you, giving the referee, and what that form does is it gives the referee the power to be able to hear your case. Now you have a legal right to say yes, that you will allow that referee to hear your case. You also have a legal right to say no to that referee as well. That is your legal right. And if you say yes, the referee is given the power granted by you to make the final decision in your case. Okay? So when you say yes, sign that document. You are giving that referee the power to make the final decision in your case. Now, if you say no, the case will remain. And remember, you can say no. It is your legal right to. That case will remain in the courtroom with the referee. But the referee does not have the power to make the final decision in your case. That final decision will be made by a judge. I just want to make sure you understand that part. All right, moving forward. Let's talk now about judicial hearing officers. A judicial hearing officer, abbreviation JHO, a former or retired judge appointed by a chief administrative judge for a one-year term, assigned to hear contested paternity proceedings, custody and visitation proceedings, and family offense matters in the family court. In New York City, JHOs, judicial hearing officers, may also be assigned adoption, permanency hearings, and foster care review cases. Generally, judicial hearing officers hear cases and report their recommendations to a family court who determines the outcome of the cases. And let me read that again. Generally, the judicial hearing officer hears cases and report their recommendations to a family court judge who determines the outcome of the cases. Now that's basically the judicial officers, the individuals who presides in the family court. Though that is a list of who's who involved with those individuals. Now, let's talk about some of the court staff that you'll find in these courts. First of all, we have the court attorney. Okay? A lawyer who assists the judge with legal research, drafting decisions, and reviewing orders is known as a court attorney. We have the court clerk. The court clerk sits near the judge, support magistrate or court referee, and supervises non-judicial personnel, prepares court orders, schedules cases, and ensures the availability of interpreters, amongst other responsibilities as well. Okay, now we have interpreters. The court provides interpreters for people who have difficulty with English or are hearing impaired in New York City as well as in other counties. With large Spanish-speaking populations, Spanish language interpreters are usually available in the courthouse. If an interpreter is not available, the judge may adjourn the case until one can be found for the individual who needs the interpreter. Okay, now we go to the petition clerks. The court clerks who dockets and files petitions is known as the petition clerk. In family court, petition clerks may prepare petitions in custody, visitation, family offenses, paternity, guardianship, and support cases. Now these petition clerks can be found in the Hall of Justice on the 3rd floor in the family court clerk's office. The very nice ladies that you will see that work in that office, and believe you me, they are very nice, very helpful, very knowledgeable women. They will assist you in any help that you need in filling out a petition, any questions that you may have about that petition, any questions being asked of you that you don't understand on that petition. You could definitely ask any of the women in that family court clerk's office. And like I said, once again, they are very friendly women, very knowledgeable women. They will be more than happy to help you and answer any questions that you may have about how to fill out your petition and what exactly type of request to put on that petition as far as what remedy you're looking for. So feel free to make sure that you take full advantage of these ladies' kindness and their knowledge, because they're very helpful. Okay, now we can go to some of the legal personnel in that court. Assigned counsel. Assigned counsel is an attorney assigned by a judge to represent an adult party who cannot afford one. In a family court proceeding is known as an assigned counsel. Now, you can be appointed an attorney in the family court system if you cannot afford one, and you will be given the opportunity to do so. Your first appearance in court is usually when the judge, magistrate, or referee will give you the opportunity to go out and get counsel for you. And they will also let you know, if you cannot afford an attorney, then one will be appointed to you. And they will give you an option. We have, of course, the Public Defender's Office here in the city of Rochester, New York, and I'm quite sure in other counties. In the city of New York State, you have the same office on which you can go get legal counsel if you cannot afford legal counsel. And they also have what is called the conflict, I believe the Conflict Defender's Office is what it's called here in Rochester, New York. In other cities and surrounding counties, they may have a different name for that individual. The Conflict Defender's Office usually represents an individual when there are two parties of the same proceeding on opposite opposing sides of that proceeding, a petitioner and a respondent, and both individuals are not able to afford an attorney. One they will send to the public defender, the other one they will send to the Conflict Defender's Office. And they're given that name because the conflict arises where the public defender cannot represent both individuals because they are opposing parties. And there is ethical issues involved there. So they have created the Conflict Defender's Office to deal with that sort of conflict. So they've given them sort of very good name because the name is very appropriate for the role that they play in the family court system. Okay. Next would be the law guardian. Now the law guardian is a lawyer assigned by a judge to represent the child involved in a family court proceeding. Okay? Now the law guardians are advocates for the children and represent their interests and wishes. They participate in all proceedings of the case, presenting and examining witnesses and evidence, and arguing and negotiating, on behalf of the child. So, any family court case that comes before a referee or a judge involving custody or visitation, the child involved in that visitation or custody issue will be given their own legal representative called the law guardian. And the law guardian's job, like I said, is to represent the child, negotiate and represent and argue its case for what they feel is in the best interest for their client, which is the child. So your child will have a lawyer as well. Okay? Now we have the assistant county attorney. Now this individual is a lawyer who represents the county, city, or in some cases, the Department of Social Services. This person is known as an assistant county attorney. These lawyers prosecute juvenile delinquent cases and file petitions in child abuse and neglect, foster care, termination of parental rights, and persons in need of supervision, which are PENS cases. They also may represent petitioners in child support and paternity cases, as well as the Department of Social Service cases where children are receiving public assistance. So when you're in a child support case and that child is receiving public assistance, the attorney that shows up for the mother who has custody of that child, who is receiving that assistance from the county, the lawyer that shows up with the mother is what we call an assistant county attorney. Or if the father has custody and the mother may be the one paying the child support and the father may be receiving some type of services or public assistance for the child, then that attorney that shows up to represent the child's child support interest is considered the assistant county attorney. Now, so moving on. The assistant corporate counsel. Assistant corporation counsel is a lawyer from the New York State City Law Department who represents the city in many of the same type of cases as an assistant county attorney does. It's interesting. Okay. Moving right along here, we have one more officer here. Let's see. Assistant District Attorney. Abbreviation, an ADA. An Assistant District Attorney is a lawyer from the county's District Attorney Office who prosecutes certain child abuse and neglect cases and juvenile delinquency cases involving serious crimes in the family court system. Now we'll go to representatives of social service agencies and others. First, we'll start off with the caseworker. A caseworker is a staff member of the county or city child protective or social service agencies. Caseworkers investigate charges of abuse and neglect, file petitions, bring case records to court, testify at hearings, and make recommendations about what should be done for the child involved. In addition, caseworkers work with children in foster care and with parents trying to regain custody of them. Court-appointed special advocates. Now, these individuals are better known as CASA workers. That is court-appointed special advocates. A court-appointed special advocate is a person who is appointed by a judge to investigate, monitor, and report to the family court on foster care placement cases. Now, CASA workers usually work side by side with individuals involved or individuals who are workers with Child Protective Services. So CASA usually works side by side with CPS involved in any cases in the family court system. Now we have the guardian ad litem. Now the guardian ad litem is a person, usually an attorney, appointed by the court to represent an infant or an adult who is mentally or physically unable to speak, or to stand in the place of a parent who is unable to appear in court. This person is known as a guardian ad litem. Now, guardian ad litems act only in specific litigation for which they are appointed. The last officer of that court is the probation officer. Now, a probation officer works for the Department of Probation and is a reasonable and is reasonably for investigating and preparing reports for the judge or support magistrate about individuals' involvement in a particular case. In addition, probation officers monitor compliance with courts, orders, programs, and in some counties help with the actual writing and filing of petitions. Now those are the officers who exist in that court. Now let's go into some other areas in our court system, which is the legal representation and assistance in the family court system. Okay? Now basically, anyone who enters into the family court system, whether it's for visitation, custody, child support, divorce, paternity, etc., you are legally have a right. You are in a position to have a legal right to an attorney. You're supposed to have legal representation. You do have a right to have legal representation in that court, as well as your child. And for individuals who do have children and you are worried about daycare for your child, because most people who come to family court, of course, have children. In family court, there are set up what they call child centers. And in these child centers, you are able to bring your children and leave your children in these places where they can be watched and supervised by professionals inside of our family court system. Now, these child centers are set up to be very child friendly. Also, you are able to get special services through these child centers, like WIC. If you are not receiving food stamps and you are in need of food stamps, you are able to sign up for these sort of special services in these child care centers. So don't worry about where you're going to leave your child, or, oh my God, who's going to watch my child while we go to the court proceeding, because they do have these child care centers and they are set up in the family courts throughout the state of New York. Now, the first thing I want to talk about here is filing a petition in court. And this seems to be one of the most difficult areas for individuals who are having their first, this is their first time going into family court. Now, for individuals who like to fill out a petition, they usually come like this, and they'll come in different colors, and the colors usually signify what type of petition that you'll need and what type of court you will be filing that petition in. First, I would like to start off by saying that the courts that I just went over, or the court officers that I just went over, judges, magistrates, referees, these individuals exist in different areas of the family court system, and they specifically handle certain type of remedies. For instance, you may be under the belief that if you file for any type of custody or visitation, in the family court system, that in that court you can handle child support, or vice versa. You may file a petition for child support, or you may be the individual or the respondent or the non-custodial parent filing for child support because you want to pay your child support. In this court, you cannot handle visitation or custody. Just like in the visitation and custody court, you cannot handle child support. These courts are two separate entities in which you go into, functioning under the same court, but you will go into these courts to file these remedies separate. So remember, when you go in to file for visitation and custody, that you would have to refile another petition for family court or child support. You'd have to file another separate petition. And if you file a petition for child support, you would have to, and you want visitation and custody, you would have to file another petition for visitation and custody. And I just want to let you know that. Now, back to the visitation court. Now, you would go to the third floor of the family court of the Hall of Justice in the family court building, third floor, the clerk's office, and speak to a petition clerk and let them know that you want to fill out a petition for visitation and custody. They will give you a petition for visitation and custody. Now, I have several here, and I'm going to make sure that I do show you the right one, and I believe this is the one on the top here. Okay, this is a petition to enforce visitation and custody, and like I said earlier, they will come in different colors, and the colors usually signify for what that petition basically is for. So I have several here, and I want to make sure that I do show you the right one. This petition here, and this is one that I just recently obtained, I would say about a month ago, and they constantly do update and change these petitions. So this should be the color of the petition that you would need to look for visitation and custody. On the front of that form, you will see here, there will be two areas in which you would need to fill out. You, as the petitioner, would fill out this area over here, and you will put all of the respondents' information on this side. The children's names will go down in this area, okay? Now, these petitions are not very hard to fill out. They do come with instructions on how to fill them out. Some of them come with example petitions already filled out, so it sort of gives you an idea of what type of questions are going to be asked of you and what the questions basically specifically are asking of you. So they come very I should say reader friendly as far as filling them out goes. And once again, you do have a group of professionals in the family court clerk's office, very nice women, that will be more than happy to help you with any issues that you may have in filling these petitions out. Now, once you get this petition totally filled out, what they will do is stamp this petition for you, and they will notarize it right in the family court clerk's office. So make sure you have proper ID on you, because they have to make sure that you are the individual that you say you are before they can notarize this petition for you. Once they do that, they will file that petition, and in a couple of weeks you will get a copy of your petition in the mail. If you are the petitioner, you will get 2 copies of this petition in the mail. One will be for you to keep. The other petition will be for you to serve the other party, which is the respondent in the case. Okay? So on that petition you will be given instructions of the proper legal way to do service. And I'm going to go through a little bit of that right now. You yourself would not be able to do service. You would have to get somebody else who's over the age of 18, or you can get a sheriff to do service for you. And I think the price of having a sheriff to do it is, I think, $40. So you can get a sheriff to do the service for you as well. And there's usually a small blue sheet that comes over that petition once they send it to you in the mail. And it should have information on it with the sheriff office numbers who do the sort of service that you would need of these petitions. Now, also, I'm going to try to see if I have a child support petition over here. This one here is also a modification of visitation. This petition is for once you get your visitation set up through the court, and say for some reason, job, change of lifestyle, whatever, you may need a change in the visitation order that you've already been given through court. You would fill out this, which is called a modification petition. And you will basically let the courts know what type of changes have taken place since the last court order was issued to you for visitation. Now, this modification petition, you would also have to serve the respondent just like the first petition for visitation. So you would have to have this one served to an individual as well. Also, there are petitions for child support, and I believe that's what this one is. And let me double check. Like I say, they update these things pretty frequently, so I want to make sure that I am showing you the proper petition. I don't think I have a child support petition over here. Let me see. Maybe this is one for child support. Let's see here. Okay, no, that one. I don't have a child support petition over here, but like I say, they all come in a certain specific color. So if you are a custodial parent and you don't know how to go about filing child support papers, what you would do, once again, go down to the 3rd floor of the family court clerk's office. Speak to the women in the clerk's office, which are the petition clerks. Speak to them and let them know that you are in need of filing a petition for child support. If you are a non-custodial parent and you want to make sure that your child gets the child support that is necessary for them for them to financially be able to make it from day to day, then you have the right to go into court and file a child support petition as well. Now, the child support petition does not have to be served. Both parties will get that in the mail. So you don't have to serve a child support petition. The custodial parent, which is the petitioner, will get their copy. The non-custodial parent, which is the respondent, will get their copy as well. Also, if you are a parent and you are paying child support and you feel that your child support, that the payments that have been ordered for you to pay, that you cannot afford to make those payments due to some change in your financial situation, you can go as well to the family court clerk's office on the 3rd floor and file for what they call a modification in child support petition. And you put all your requests in that petition, once again, like the original child support petition, it does not have to be served to the respondent, or in this case, the custodial parent. Both of you will get your copies in the mail in a couple of weeks once it's been processed through the clerk's office on the 3rd floor. Now, one important petition I would like to show you is, and I believe this is the petition that you would file, which is a violation petition. This petition you would file if any court orders that has been given to you through child support court, through visitation court, are not being honored by the other party. If you are a father or a mother and you are the non-custodial parent and you are not getting your visits like the court order said that you should have them, then you would go down to the family court and you would ask for a violation petition. Like I said, I just recently obtained these, so they are usually categorized by color. So I believe this would be the actual color of that petition that you would need. And you would request that petition, fill it out, file it. Now the violation petition, I believe you would have to serve as you would the initial visitation petition. Okay? But if you're not getting child support payments, if the individual is not paying the child support that the court ordered them to pay, then you would file this very same petition, violation petition. They are not obeying the order that is deemed for them to obey by the courts. Now, all these petitions are important in the family court system, that you file these petitions, because the only way that you're going to get judicial relief is that you must file these petitions in court. Okay? And like I said, once you are in that court, you will be given legal representation if necessary. If you cannot afford an attorney, one will be appointed to you. And you will also have legal representation for your child in these courts as well. Your child will have legal representation and given what they call a law guardian in the court system as well. So basically, these are the basic steps. The officers in these courts, as well as some of the history of the family court system. Now, my advice to you, if you can, is to go through some of the information that I've just given you. And in the future, we will be taping other shows, giving you more information on the family court system and how it functions. Okay? Now, like I said, filling out the petitions are very simple. You get plenty of help down in the family court system. They're all separated by color, so that it is pretty easy, based off of what you just saw, to go down and seek some type of judicial remedy in the family court system. Now, I always do this. I always advise any party that if you can't settle your visitation issues, your financial issues involving your child without going to court, my advice is to go ahead and do so. Okay? Because the family court can turn into a place that could cause a breakdown in communication between you and the other individual. So if you can settle that case without going to family court, then my advice is that you take advantage of that and you go ahead to family court and get your case settled outside of family court, basically. But if you can't, then you go ahead into family court and you go ahead and get whatever judicial remedy you can get in family court. And once again, you know, the family court is open from 9 a.m. to 5 p.m. Also, like I said earlier, for those who have children, they do have what they call child care centers in the court system, in that family court system, which you can bring your child. And like I said, these environments are set up beautiful. They are very child friendly. They have professionals inside these places that are able to take care of your children while you handle things in the court, so you don't have to worry about child care or where you're going to take your child as far as showing up to court goes, because they do know that everyone has children in the court system. They also have activities for the child to do, drawing, finger painting, very great places for you to be able to leave your kids, set up just like a daycare. And also, I'm going to remind you as well that through these centers, if you don't have these special services like WIC, food stamps, even access to child care, these centers are able to assist you in getting these special services if you are in need of these special services. So they're very excellent places for you to take your children to while you are sitting in the court system, waiting to be seen by a judge, magistrate, or referee. Okay? Now, also, I want to remind you of another thing. Once you go in front of a referee who handles visitation and custody, these are not judges, they are lawyers. You do have the right to have your case heard by a referee and have that referee be the final decision maker in that case. Or you can have a judge be the final decision maker. And the way to have that done is, remember, your first day in that court, you will be given a form to sign. And the referee will instruct you that this form that he has given you or she has given you to sign gives them the right to make all final decisions in your case. They will tell you this because it is your legal right to know this. So you would have the right to say yes. And if you do say yes, this referee will be the individual making the final decisions in your court case. If you say no, the case will remain in the court of the referee, but the final decision will be made by a judge. It will not be made by the referee. And remember, this is your legal right that you have to sign that paper. Once again, I want to go over one more thing. That once you go into a custody court, that is not the place where you solve child support issues. Nor is the child support court a place where you solve custody issues. Thanks for tuning in for this educational show. I hope you find the information that I gave you pertinent, and I hope it helps you in pursuing whatever judicial remedy that you are looking for from the family court system. My name is Joe Lewis. You've been watching Justice Now, coming to you from Public Access Television, the People's Network. Thanks for tuning in. Goodbye, and may God bless you.